The other day I received a comment on one of my videos that said, "You, the attorney, is what's wrong with the legal system in today's society in civil cases." You want to know how I responded? Come join me for a walk near the marina as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. First, I said I totally disagree. I said, why aren't you speaking up for the injured victim? Why aren't you commenting on the fact that this patient suffered significant and permanent disabling injuries? I don't see you voicing any concern for the fact that this patient suffered horrible injuries and will never be able to work again. I don't see you voicing any concern for the fact that this patient did absolutely nothing wrong to cause her own injury. And here you are focusing on me as the attorney, as the person who is instigating a lawsuit, when in fact it's just the opposite. I am not instigating anything. I am not encouraging the client to go ahead and bring a lawsuit, especially if it does not have merit. Because in New York, we are required to have a medical expert review the case to confirm that there is a valid basis for a case. In fact, if we do not have a medical expert to support our position, we are forbidden, we are prevented from going ahead and filing a lawsuit on my client's behalf. That is the rule, that is the law in New York. When I saw this comment from this person who posted about the fact that we as plaintiffs' attorneys are the ones who are responsible for this judicial mess in civil lawsuits, I took umbrage with that, meaning that I was actually upset hearing that. This person was so focused on, hey, it must be the plaintiff's attorneys, the attorney who represents these injured victims, who are the ones who are going ahead and instigating these medical malpractice lawsuits, when in fact it's just the opposite. It is the injured patient who comes to us who says, listen, I don't know how I'm going to put food on my table. I don't know how I'm going to put my children through college. I am no longer able to work. I am permanently disabled. I am no longer have the ability to do those things that I used to be able to do before, and I don't know where to turn. I don't know what to do for myself and my family. Can you help me? That is the first step in what occurs when an injured patient calls our office. Not, hey, I'm going to sue this guy and I'm going to get $10 million and screw everybody else. No, that's not what happens. Most of these injured patients turn around and say, listen, I've never brought a lawsuit before. I don't know how this stuff works. Can you help me see if I have a case? And if so, is there any way that I can get compensated for all of the harms and losses and damages that I incurred because of this person's carelessness? So now, if a doctor does in fact confirm that this injured patient has a valid case, now we can go ahead and file it. And you should know something else. The goal of a lawsuit is not to prevent the doctor from practicing medicine. The goal of the doctor is not to have his license revoked. The goal of a lawsuit is simply to compensate an injured patient for all of the harms and damages they suffered because of their negligence, because of their carelessness. That's the goal. There's really no other purpose for a lawsuit. And in our civil justice system, in our society of civil justice and civil laws, we cannot take an eye for an eye. A patient cannot go and do the type of harm that they received to the doctor, then they'd go to jail. So instead, the law permits and in fact allows the injured patient to go ahead and sue for that compensation. That's the purpose. So when this commenter said, hey, you are the ones who are causing costs to go up and medical care to go up and the cost for all these things to go up, I said that may be a byproduct of everything that occurs. But that does not excuse someone who is careless, because someone who is careless must take responsibility and account for what they did, for their actions. And the problem with so many of these medical malpractice lawsuits in New York is that the doctors and their attorneys refuse to accept responsibility until we are deep into the litigation process. Many times it doesn't happen until we are deep right before trial. So we've now spent 2 or 3 years litigating the case, and what happens? What happens is that because the doctor and his attorney refuse to accept responsibility, now they go through the litigation process, and many times, not always, but many times, they come to the realization that, you know what? Maybe we did something incorrectly. Maybe something was done carelessly. And maybe it did cause this patient harm and injury. But you know what? Maybe your injuries really aren't as bad as you claim them to be. So now the shift of the entire case focuses from, hey, I did nothing wrong, to, you know what, let's talk about your injuries. Let's talk about your damages. Maybe you were injured, and if so, let's see what type of compensation you really deserve. In that instance, now we get to talking, and we begin to understand their position, and they feel that, hey, yes, your client suffered injury, but it's not as significant as we make it out to be. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.